Boa tarde. What else? uh, my name is Paulo Sotero. I am the director of the Brazil Institute, and I would like to welcome you all here this afternoon on behalf of not only the Brazil Institute, but also the other three programs of the Wilson Center, the Latin American program, the Canada Institute, and the program on America and the global economy that are jointly sponsoring this discussion. It's a special satisfaction for me to host this event for something that one of our speakers here knows very well. It's the Brazil Institute interest and connection with the topic of innovation. Actually, Jorge Avila, who is the president of the Brazilian Patent Office, the National Institute of Industrial Property, was here with us in 2008 when we launched a series of discussions on innovation policies and business strategies in Brazil that resulted in a publication available at our website in English and in Portuguese. And he was one of the greatest contributors to that series. Also, we have continued to work on the issue of innovation, which is basically a discussion about the degree of integration of economies into the world economy, a very important subject nowadays in Brazil. We have just finished, the Brazil Institute has just finished a series of three congressional study missions on innovation. We had in 2011, 12, and 13, we had a group of about 30 Brazilian members of Congress, congressmen, deputies, and senators, key people in the discussion of innovation policies in Brazil, that they were with us here at MIT in 2011, at King's College London last year, and we just came back from the University of California at San Diego, which is one of the greatest centers for innovation in the United States. We are going to come out with a book. We have summaries of what happened in the first one and in the second mission also, and we are going to come out with the third one, and then with the summary. And very interesting, I'd like to share with you this information. It's that the Brazilian congressman, building on the discussion that started here when Jorge first came, asked us to help them bring to the Brazilian Congress now a discussion on the Bayh-Dole Act of 1980, which is a landmark act for innovation in the United States. So we are doing, that's what we do here at the Brazil Institute, at the Wilson Center. We try to foster good debates on good, productive public policy. And it's in that spirit that I welcome here this afternoon leaders of the this field. Michael, can I have the write-up with the presentations of the four? Because it's really very much part of our program. I think it's the core program now at the Brazil Institute. We do other things also, but we are always trying to focus on innovation because, as I said, it has to do with a key development in Brazil, which is Brazil's integration into the world economy. I have the honor to have with me and to have with us here four experts in this field, two of them from the region, starting with Jorge Avila, the president of the Brazilian National Institute of Industrial Property. Jorge is from Rio de Janeiro, a civil engineer. He has a master in business administration from the Federal University of Rio and a PhD in public health from the University of Rio also. He has worked in different companies in Brazil, has been a leader in this field and has had this position since the President Lula's administration. It's very important to have a person that has had continuity in this field, because normally positions as important as the INPE are become part of some sort of political trade-off, and it's very important that George stays there. It's a recognition, I think, by the Brazilian government of the importance of this issue. Let me introduce you also to José Luis Londoño. He's a superintendent for industrial property in Colombia, but he's also now the president of Prosur, which is a very interesting initiative of South America intellectual property offices that have about some 6 years ago, they joined forces and started cooperate with a view of sharing experiences and cooperating in the implementation of policies and practice in terms of patents, trademark protection. And it was from their initiative when they contacted me to share their experience. They just had a meeting in Washington. They are, I think, in the process of having this meeting. But in the spirit of collaboration, they invited their colleagues from the United States and from Canada to share experiences, to work together. And we have here from Canada, Constantinos Jorgaras. He is the Director of Policy, International Affairs and Research Office at the Canadian Intellectual Property Office. But he is here also to talk to us about something called the Vancouver Group, which is this similar exercise. I don't think it's much older than Prosur, but where the patent offices from the UK, Canada, and Australia do the same sort of activity of comparing, cooperating in examining patents. How you do that? How do you do your work in that field? And last but not least, Marks Getlich. He is the Senior Patent Counsel and Director of Patent Policy and International Affairs at the U.S. Patent and Trademark Office. And he is also going to talk about a similar exercise. It's the P5. Is that correct?
IP5. No.
Or P5 or 5P?
IP.
IP5. Too many acronyms. But, and this is a group, if I recall, from it's the United States, China, Korea, Singapore, Japan,
and European Patent Office.
and the European Patent Office. Now, I should have told you that Mr. Londoño has a law degree from the University of Columbia. Obviously, he's an expert in competition law. Also, that Mr. Jorgaras is an expert in his field, and he has studied in the area of science and technology. You can read their bios in this small summary we have. Also, Mark worked at one of those innovation places called the AT&T Bell Laboratories. That's where all this, the story, I think a lot of people in Brazil that are leaders in innovation come from there, including a great partner of us, Brito Cruz, from the scientific director of FAPESP. And he has the great quality of being from, well, I think you're from Missouri, but you studied at Denver,
Yeah.
Colorado, where my grandson lives, so it's a great place. I always have a chance to, when I have a chance to mention Colorado, I always use it. So with that, I think the way we are going to start, I think José Luis, you would like to start and with presenting, why don't you just introduce the video and then we will.
Press the button.
Yes. Is it on?
Yeah. Well, thank you very much. Honestly, I wasn't prepared to do this presentation in English because it's very, very rusty, but I'll try to do my best and forgive me for all my mistakes. But to begin with, we wish to show you a brief presentation of what Prosur is, which is a video that we taped and launched last General Assemblies of WIPO in October 2012, and sort of shows you what Prosur is in short terms.
Yeah, just before you do that, let me just, I forgot to introduce and recognize one person that's here. There's a dear friend, Arturo Valenzuela, former Assistant Secretary for the Western Hemisphere, the State Department, former National Security Assistant to President Clinton, professor and a dear friend, and I'm very honored to have you here, Arturo, for this presentation. And now we can hit the button. If you prefer to sit here.
The development of a country goes hand in hand with stimulation of entrepreneurship and innovation. Creativity and knowledge must be managed and protected in an efficient and modern way. In the last decade, industrial property has evolved into a dominant theme in the global economic and political agenda for its relevance in international trade and its inclusion in development strategies of countries. Conscious of this change, Industrial Property Office of South America have adapted to these new technological and legal realities. Through various bilateral and regional meetings, we have concluded that in many aspects, our IP offices confront similar problems and face the same challenges, with cooperation appearing as an essential tool for achieving their objectives and contributing to intra-regional solutions. With this conviction in mind, carried forward with the technical support and funding of WIPO and the Inter-American Development Bank, in August 2008, 9 South American countries joined forces to launch Prosur. Among its objectives, Prosur will create a common platform for the integration and exchange of information, experiences, and technical and scientific knowledge, promote cooperation, and increase the supply of new products and services to users.
Surge entonces como consecuencia de una necesidad común de ver cómo logramos ayudarnos mutuamente entre nosotros. Y a partir de la voluntad de cada uno de los directores de las distintas organizaciones de los distintos países, fue creciendo, nació y creció lo que llamamos el Prosur.
To date, there have been various executive and technical meetings in Quito, Buenos Aires, Montevideo, Lima, Rio de Janeiro, and Santiago. These meetings are part of a program that aims at establishing the institutional and technical foundations that give formal life to Prosur. 9 countries of the region, Argentina, Brazil, Chile, Colombia, Ecuador, Paraguay, Peru, Suriname, and Uruguay, have decided to strengthen capacities in industrial property in their respective nations through Prosur.
El marco es el marco de la economía del conocimiento y de la colaboración entre actores de distintas partes. Lo que queremos lograr es que América Latina esté en el mapa global de la innovación. Y la interacción, la colaboración entre oficinas es parte fundamental de esto, pues crea la posibilidad de que los usuarios tengan sus derechos reconocidos con sencillez en toda la región.
Prosur is the forum that will establish mechanisms for cooperation between the 9 countries and which will render the intellectual property system more accessible to citizens of the region. Additionally, the project will contribute to improve the quality and agility of industrial property services. In the area of patents, collaboration between examiners will help to expedite and enhance quality of final decisions. In trademarks, Prosur will work on schemes adjusted to the realities of intra-regional trade that facilitate access of entrepreneurs in the region to all countries of Prosur.
Prosur es una iniciativa regional tremendamente importante. Es una iniciativa que, por supuesto, está focalizada en temas de propiedad industrial, es decir, temas muy técnicos, pero en mi opinión tiene también una dimensión política fundamental, es decir, la contribución que va a hacer este foro técnico a la integración sudamericana en este caso, va a ser, estoy seguro, reconocida en el futuro.
Industrial property offices in the region, being aware of the new paradigms of a globalized and competitive world, are resolved to provide the best possible protection and increase awareness of industrial property of innovators and entrepreneurs from the region. To promote the protection of industrial property and the dissemination and access to knowledge is the commitment we make to all who live and work in this land of entrepreneurship and innovation. Prosur, for a more innovative and integrated region.
If you want, podríamos cambiar acá. Okay, so
Go ahead, José Luis.
this is one of the outcomes that we have since we gathered together in 2008, when we found ourselves, and I mean our offices and our countries, in a very similar position as to how are we addressing IP, which is basically that we all concluded that we needed to enhance our economic developing plans. And so we started thinking what we should do in order to cooperate and to overcome all the problems that we were commonly facing as an IP offices. So first meeting was, as I told you earlier on, back in 2008, then 2009 in Uruguay, and we ended up presenting the IDB a project of cooperation, which was obviously granted, and we started with in March 2010 with the first technical committee meeting in Bogota, where they just set forth the roadmap for the technological matters that were to be done in order to develop all this project. We have had more than 10 meetings during 2011 and 2012 among our the IP offices directors, where we have had different, obviously, discussions as to the best model to come out with different solutions and different ideas. But most importantly, I wanted to show you the main objectives of the project. The first one was to build a common platform where all the offices could share their information in order not only for us as an offices to see what other offices are doing and to see how can we improve our practices, but also to show the users how the systems on the different 9 IP offices are working. In order to do so, there was another component of the project, which was a portal, an internet portal, to offer different services for the users. And the third one would be a collaborative patent examination system. Obviously, I am only mentioning 3 because the first one, the first outcome should be the drafting the general agenda and objectives and rulings for the 9 offices to work together and to be integrated as what we could say one office working for one purpose. So mainly, this is the structure of the Prosur project. We have what we could call a board of directors, which is comprised by the IP offices directors. There are 9 of us: Brazil, Argentina, Chile, Colombia, Ecuador, Uruguay, Paraguay, Suriname, Peru, y Paraguay. No sé, I don't know if I'm missing someone, but there's 9 of us. There's a pro tempore director or CEO, which has the charge of lead the group for 6 months. In this semester, I have the honor to be that president. Prior to me, there was obviously Argentina's presidency, then Brazil, and then Chile. And we have 3 different technical committees. One of them for trademarks, which is comprised by the trademarks directors of each of the offices, the patent committee, also comprised by the patent directors, and one for IT committee, which is transversal, but most importantly, I will say it is the backbone of the project, as one of the main components is to create a common platform. Also, we have a technical secretariat, which is carried out by one of the INPE's, Brazil INPE's officers, Leopoldo, and one general coordinator who is in charge of link and socialize all the information and the achievements and milestones we've achieved with the IDB project and requirements to keep going on the project. As I told you, these were the outcomes expected: integrated platform, an internet portal, and a comparison examination system. The technical committees have had different meetings, and I wanted to show you one of the outcomes we've had here. This is mainly a curve of our how we have developed this project, and I wanted to show you this way because I always do kind of a comparison when you are uploading or downloading an app or a software, which is the first 40% takes too long and the rest goes really quick, and it's just the same curve that you find here. In 2008, 2009, and 2010, it was going really slow because everyone was trying to show their experience, their position, and harmonizing all 9 offices is really hard. Yeah, it's very, very hard. In fact, we were told that IDB was very proud of this project because trying to harmonize and get in accordance 9 different countries, it's a very, very long shot project. But at the end, since 2011, and since we have set for the basis of the project, we have gone through a very huge amount of terrain, and we are in fact at the end of the first phase of the project. We have achieved the majority, if I am not saying all of the outcomes. For start with the first component, which is the general drafting and ruling of the project. We have signed a cooperation agreement within the 9 offices. So it is formal that we are committed to each other to help each other in working to solve out oral problems. We have hired one consultant, external consultant, a former Minister of International Affairs from Argentina, to work with us in trying to draft a state-of-the-art picture as to how is each one of the offices and the countries in terms of legislation, technical status, IP regulations, in order to see how can we work to create one single institution that administrates and sustains all this project. And finally, obviously, we drafted and agreed upon an operating ruling, which basically sets the basis of how to be part of the project, how you can go out, and how all this presidency rotation goes, how the decisions are made. The second outcome, which is the common platform, we already done it. We went through different contracting stages. We had to contract an expert to see the technical state of the art of each of the offices. Then to draft the terms and conditions for a different enterprise to create the whole architecture of the common platform, and it's going to be delivered in the next month. So we're going to have the tangible product as, I don't know, shorter than expected. And also what we did was we try and tested different ways to share our information through different systems. The first one was the WIPO case, which is software that was created by WIPO in order to work with the Vancouver group, which is going to be explained by Contastinos in a few minutes. But the way it works is that you upload, each examiner of each office uploads their examination reports, and the other offices can take a look at what the examiner has performed, and they can rely on that examination to produce their own report or their own decision. We found that software a very useful tool. However, we wanted to go further. We wanted to our examiners to discuss to each other in order to enhance quality. And in order to do so, the Brazilian office produced a software called IPEC, and it has been developed by the Brazilian office and by the Argentinian office, by means of which we can also share not only the examination reports, but to interact to one to each other in order to produce one single examination report for one patent application that has been applied for in the 9 offices, or at least 2 offices of that are part of the project. Up until now, the software has performed well. We are at the final stages before it is launched, but as I told you, it's working well. The third component, it's the model of the examination. As I told you, we first used the WIPO case, but the most important part of this is that in order to make some examiners work together, we have to build trust among them. Normally, one examiner from one office believes that its examination is better than the other examiner from another office, regardless of the fact that they have the same profession, the same career, and the same knowledge, normally. So we conducted different workshops among them and with them in order to show them that there were more common denominators than differences in terms of how they performed their search and their examination reports and how they looked at the state of the art. Then obviously we came out with the IPEC system, and we are at the final stage. And there's a 3.A component or outcome, which is that in the middle of this process, we figured out that we could also do some things in terms of trademarks. We know that it is different, the system, from the patent system. It's more, the territoriality principle is stronger as to the registrability. However, we had to offer the users a tool to facilitate their transactions, to facilitate their entrance to each of our offices and countries. And so we came out with an idea of producing one single application form for the 9 offices, so that at least with that application, each applicant will overcome all the formal requirements. And so if you file an application through this application form, you won't have an office action issued by none of the offices, and the application will go to the second stage, which is a very, it's not a least outcome. I mean, it's very important for applicants. And most importantly, all these achievements are showing us that we didn't need to change a comma in our laws. It's one of the main important conclusions that we have with this project, because obviously changing our laws implies a lot of time, discussions, and the applicants and users are not are not willing to wait any more time to see how we can reduce procedures and formal requirements that are obstaculizing the commerce. Finally, one of the components is this video that we just showed you, and we are at the final stages of the internet portal, which is at this moment only for information purposes, but at the end it will be integrated with the common platform so that it will be the tool for the applicants and for our internal users to work with all the products that we have achieved and produced. How are we related to third parties? Well, as the video showed, we have worked closely with WIPO. They bring us and share with us technical assistance. And also, we have invited to many of our meetings different offices from different parts of the world so that they can be there as an observers. So in different meetings, we have had the presence of Costa Rican office, Mexico office, Spain, the EPO office, and so forth. What are the main challenges? Well, this project, as an IDB project, it's about to finish in the next 2 months. We have asked for a extension of time for 6 months in order to conclude all the outcomes. But at the end, we believe that we have exceeded the expectations. And so we want to make this project sustainable. And so we need some institution that makes it sustainable and keep it sustainable. So the main challenge is to create one institution that handles and carry out all these applications, distribute the trademark applications, and to take care of all the financial and technical issues that obviously are to come once we use the system more often. That's basically the presentation, and I'm very glad to answer any kind of questions.
Who is next? Should we?
I think we should go to the...
Yes, we should go to Vancouver Group, to IP5, and then open for questions, or if George wants to make a remark. So why don't you go ahead then and present the Vancouver Group perspective on this?
I don't have a present, I'll just speak. Thank you very much. I appreciate being invited here this afternoon to speak about the Vancouver Group and tell a bit about our experience with working amongst intellectual property offices and the importance of that work to support businesses and innovation. Just to step back a little bit, what you've seen here so far in terms of Prosur and what I'll speak to in terms of the Vancouver Group is really an effort to help connect offices, to help connect the work that we're doing, ultimately to support businesses and innovators. So why is this so important? It's critical because the frameworks for intellectual property are domestic in nature. We know that. Coming from Canada, I think we're in a bit of a privileged position because we are a small open economy, so it forces us to think globally all the time. And I've done a lot of work in innovation and S&T research, and understanding that the innovation cycle, if you will, or innovation value chain, or whatever you want to call it, really starts from basic research right through to R&D, through to commercialization and getting to the market. From a small open economies perspective, we realize that that happens globally. It has to happen globally. Canada has many strengths in terms of basic research and R&D, but for companies to be truly successful, they need to play on the global stage as quickly as possible. So within a domestic framework for intellectual property, there are some limitations for those companies who are at the cusp of going global. So what we're trying to do amongst our offices is to create that framework, if you will, to allow to create the platform to allow companies to then excel globally. So it's absolutely critical. And when I talk about the framework, if you will, it's the laws, it's the regulations, it's the treaties. There are international treaties. The World Intellectual Property Organization has many treaties in place. That takes us part way. But what's critical is how it's actually implemented at the office level. It's what we do, but more importantly, it's how we do it. And how we do it, I'm talking about some very fundamental tenets of our operations. We're talking about the timeliness, how quickly we can turn around some of the examination that's required for intellectual property, because it's the timeliness that allows these companies and innovators to get to market quicker. And that's critical. And that should proceed as quickly as the companies wish to proceed. It's the timeliness. It's the quality, how we ensure that the applications that come in and the patents are of high enough quality to be able to operate on a global stage and withstand the various challenges that they face after the office is done with our work, but to ensure that the IP is of a certain quality to allow the companies to excel. It's also in terms of how we reduce our own costs so that the companies and innovators aren't burdened with the extra work that would need to be done, especially when you're operating globally. To receive intellectual property, it's a very expensive process domestically. To do it internationally, you multiply the cost by the number of jurisdictions you're interested in entering. So this is where the work amongst offices can help to create that framework, patchwork, whatever you want to call it, to ensure that there's a smooth movement of ideas, companies, and innovators across border. And that's what's critical. So what we're trying to do here through Prosur, through the Vancouver group, and through IP5 as well, is to ensure that the offices, our work, and how we do it is really catching up to where businesses are already at and how they're operating globally. So that's the driver behind what we're doing. Let me tell you a bit about the Vancouver group. So as was mentioned earlier, the Vancouver group comprises the UK, Canada, and Australia. We formed in 2008. It seems like a rather a distant relationship. We've covered pretty much, 3 continents. So there's no natural flow of business or ideas across those 3 offices, but there is a critical component. But what we found most important was that we identified ourselves as like countries, similar legal background, similar types of industrial structures, and similar challenges in terms of connecting with global IP systems. So with that common background, we then came together and we developed some programs very similar to Prosur and IP5 to help us as offices understand what we're doing and do it better for customers. And with that, we've had some very positive effects, and hopefully we've got some lessons learned that we're sharing with other countries as they group, again, to connect that global framework. So what we tried to achieve were 3 things. First, we were looking at business performance and how we understand our business, very internal process, but critical for, as I mentioned, timeliness and reducing costs. We also have a program of economic research, and I'll get to that in a moment, very critical as we try to understand global trends and how we can support innovators and businesses. And thirdly, as was mentioned earlier on Prosur, was our cooperation amongst our countries in terms of, we call it mutual exploitation. It's basically how we share work, so we don't duplicate work and therefore reduce costs for innovators and companies. Business performance, I won't get into that too much. It's a very internal process, but what we've done is we've learned a lot about how we can measure our performance to ensure that we're meeting best practices. The economic research, I think, is fascinating. Again, just as I mentioned, innovators and businesses are going global. What we're noticing as well is trying to understand the global trends. It's quite challenging for any intellectual property office or other research institutes. So amongst us, we've created, I think, a rather forward-looking research agenda that'll help us understand some critical issues. Issues such as backlogs for example. So there's been a tremendous surge in intellectual property activity internationally. That's having quite a bit of burden on some intellectual property offices. And what that results in is either a slowdown of granting of rights or a stockpiling of ideas. That's the backlog. That has a direct impact on innovation. That means ideas are not getting rolled out and brought to the market quickly. That has a direct negative effect on businesses and the economy. And we've got to free up that backlog as quickly as possible. That starts with understanding the trends. It also then leads to the kind of work we do as intellectual property offices. Other key issues, and I'm sure looking at the invitation list here, there might be some people directly affected by this, but we're looking at things such as litigation. We're looking at things such as enforcement. Many have heard about non-practicing entities or trolls, as they're sometimes called. There are a lot of anecdotes out there. There are a lot of real cases out there. There's not much economic analysis to understand what are those trends, what are the real costs to society, and with that, how do we then address this situation globally? So that's the economic research agenda. And now let me turn to the mutual exploitation, or what we do in terms of work sharing. It's critical, again, as an office, we need to understand what we do and how we do it. And to do that, we try to, as much as possible, build on work done by other offices. So if a company applies in both Canada, the UK, or Canada and Australia, what we'll do, instead of going through the whole process twice to duplicate efforts, we will build on where the others left off. So this is an element of work sharing that helps us accelerate the IP granting process. Sounds simple. At the end of the day, though, it means that we need to understand each other's systems. We need to build trust in each other's work and in the quality of each other's work, and we need to build transparency. And those are pretty big objectives. And it's through this ongoing collaboration through the Vancouver Group, IP5, and Prosur that you see a convergence, if you will, of the capacity of these offices, and that's where we're going with the Vancouver Group, and we're quite hopeful in terms of seeing how Prosur has developed. One last thing I would like to note, now that I've got the microphone, is in terms of cooperation amongst offices. Yes, there are some regional groups that are forming, but there are also some direct bilateral arrangements or understanding that we have. And in fact, it was 2 years ago that the Canadian Intellectual Property Office with Brazil, we signed an MOU to help us collaborate to ensure that companies moving between Canada and Brazil also benefit from the offices and our understanding of our work. So it's that kind of work where we try to, as best as possible, catch up to where businesses are already operating. So I'll leave it at that, and I'll turn over to my colleague from the USPTO.
Thank you. Pleasure to be here. My name is Mark Gutlick. USPTO has been certainly involved in projects with other countries over many years. As was just mentioned, the similar concepts of why we're involved in some of these projects, I couldn't have said it any better than what you just heard from the description of the Vancouver Group and also from the Prosur colleagues. Every concept I find is so similar to exactly how the U.S. has approached the issues and the problems when working with other offices. Our work, in some sense, was thrust upon us as long ago as in 1973, when the origins of the Trilateral Cooperative Group formed, which was the U.S., Japan, and European Patent Office, representing about 72% of all of the world's patent applications within those three being handled by those three offices. Now, that's where the beginning of the cooperation started, and as electronics developed, that many of course of the opportunities for coordination and collaboration came around just simply IT-oriented efforts to convert the 19th century to the 21st century without simply duplicating or automating the 19th century. Our preference always has been to create something that's new and better, and throughout that process start integrating the user community and the user's views and the user's needs into that whole perspective. Segues into the 2007 timeframe when, in the meantime, the world changed just a little bit, and we noticed that who are handling the most patent applications in the world happen to include 5 offices now. The 3 offices, Japan, European Patent Office in the US, but also China and Korea. So suddenly we have what became known as the IP5 group. Same concepts, same interests, same desire, all focused on the 3 main issues for every topic that we've addressed is to address cost, quality, and timeliness, not only from the office's perspective, but from the customer's perspective, the user's perspective. After all, that user is locked into only one provider in every there's only one national office for every country, and it's very, very easy, perhaps, for that provider to become myopic in the providing of their services, and that is a very, very dangerous thing to allow to happen, because that has a direct impact on innovation, in the economics of the country, and many, many other things just start simply falling apart. You may also have noticed, certainly in the U.S. Patent Office, there has been a recent popularity, and that's also true in many other offices, where you see practitioners, you see non-politicians in the heads of patent offices, and with great success, I should say. Not just in the U.S., but in many of the world's offices, as I see this developing. I too came from industry as recently as last September, so I understand the pain that the users go through, and that is translating into offices' actions and initiatives, which I think is quite important. So, with the IP5 specifically, let me just brief you on the most immediate developments. Here we are in the 6th year of IP5. It's simply a rotating secretariat, if you will, where each year, each one of the offices takes a turn. U.S. took the turn first. Here we are in 2013. We are hosting yet again in an upcoming meeting in June of the heads' offices. In between the annual heads meetings once a year, there are numerous sub-meetings at the working level to actually get the work done. What I wanted to also share with you is we started out, you might recall, in many of the press announcements, there were 10 foundation projects that existed at the very beginning of the IP5. They were rather strictly set up and somewhat formalistic. Every office had 2 projects to work on. No office crossed the boundary into the other office's piece of work, because here we had to get a relationship together without much of a common denominator other than lots of patent applications to process. There was no size of office necessarily or continental relationship. So we're simply thrust together. Those 10 foundational projects have evolved very, very rapidly into much more of a roll-up-the-sleeves kind of a relationship where we have specific working groups now. And these working groups are the groups that meet regularly throughout the year working on projects. One in particular, I'll highlight a couple of projects across the 3 groups. One working group is for patent classifications. A second working group is IT-related improvements generally. And the third is to working on work sharing and quality issues, work product quality specifically. With classification, you may recall in January of this year, we have a cooperative patent classification system that was launched between the U.S. and the European Patent Office. This is not to say that we've left the other 3 offices out of this. No, the other 3 offices out of this. The idea was quite simply that when you have 5 offices with so many different sources of income and governmental structures to work within, there's no way all 5 offices can move together. So it's very important to have a flexible structure so that any 2, for example, or 3 of the offices can proceed forward with a project, make proof of concept, bring the other offices up to speed quickly, especially when there's IT roadmaps that are all over the place for each of these different offices. U.S. and European Patent Office went through a fair amount of pain, I might add, to actually reclassify millions of documents so that we could launch this effort, and also lay out a plan so the other 3 offices can eventually come along as they help to reclassify, understand the system, and eventually will converge on the same classification system. The result being an absolute rock-solid foundation for work sharing, because every examiner will truly be speaking the same language in terms of, I searched in this category, found these results, and every office will understand exactly what that means and be able to begin from that point to do whatever their top-up might be or their continuing work. Classification is an enormous effort that the IP5 is working on and sharing with other offices at the moment. When we get to IT-related issues, there's any number of them, from the Common Citation Document project, which was a rollover from the trilateral years. Common citation meaning you see what WIPO turns out for a citation document. You see every other office coming up with their own version of that same citation. Why can't we have the same reporting structure so that X and Y art is X and Y art no matter what country you're talking about? Simple things like this are actually somewhat monumental in the office structure, with a variety of other issues that I'm not even going to get into for IT related. There's just no end of them. And then in work sharing and quality, PPH, Patent Prosecution Highway, is one of our cornerstone work sharing initiatives. That isn't an end in itself. That was a proof of concept that has blossomed into somewhat of a tangle of bilateral relationship or bilateral agreements between 27 offices now. And we're shifting that within the IP5 structure into a next generation where the requirements are all the same across all offices. There will be some background identical agreements moving towards a plurilateral kind of agreement where simply Patent Prosecution Highway fades into the fabric of what we ought to be doing anyway, is sharing the work product from one office to benefit the head start of examination in a second office. Not losing the sovereignty of any office, but simply leveraging that work of one examiner to launch the continuing work of a second examiner. The whole purpose here being it strengthens the national office, it strengthens the interest in inventors and innovation in that national system. And we believe firmly that whether it's the U.S. or Canada or any other country, you strengthen that national office and you strengthen the innovation cycle going on in those countries, and we will continue to see a flourishing international system. And that international system is where we definitely have to have the cooperation. Otherwise, it becomes more of a cumbersome effort versus a smooth effort, and that's exactly what the users deserve and demand when you look at it from a cost, quality, and timeliness perspective. One of the major projects you'll see coming out of our work sharing also is a thing called Global Dossier. You've actually heard bits and pieces of how this might fit in. I'm not going to get into the IT aspects of it, but we have in Prosur, they have their EPEC system that could actually easily be a node within a collective network of countries that can include countries that are basing their connectivity and network connectivity on WIPO's CASE system, or among the IP5 countries with the One Portal Dossier. But we can connect all of these networks as nodes in an overall global dossier so that office to office can have connectivity, network connectivity for sharing of work product, And users can also be brought into this, so they're seeing the portfolio of their client in, you name it. Click on whatever office you want to click on, and you're going to see what's happening for your patent application in all these other countries. Same with trademarks. Something along the lines of one example that is used is something along the lines of the Amazon model, where you go to one portal for a company called Amazon, but you can buy books, goods, and services from a host of other companies that are connected within this network, but it's in a convenient single one-stop shopping, in a sense, for the user as well as for the offices. I'm going to stop there because I'm really quite interested to hear from the questions that we have from the audience.
Unless George has something to say, we could go. Do you have? Yeah.
Very short comment on the relevance for Brazil of all this which has been said. First of all, I'd like to thank you very much for the kind reception here for hosting this meeting. I think it was for us an opportunity to share experiences with other people and with the interesting people we always have the ability to join here. So thank you very much. We in Brazil, we have since a few years rethought on the way Brazil should participate in the so-called international intellectual property system. Brazil used to be very critical, very skeptical of any kind of international cooperation in the field of IP. And I'd say that this was not only a Brazilian posture. I think that in whole South America, there was this sort of a mistrust in what might be the output of such a cooperation. And this was probably due to a very internally oriented development process. We have had during many, many years a very closed economy. Our process of development in Brazil and in most South American countries was based on import substitution, and shifting from this model to a more open economy has been a very recent achievement, and it has much to do with the recent development of the region. But what we could notice since a few years ago was that the IP regimes and the IP policies should somehow move together with this move in the development model. This was recently recognized by President Dilma herself. And 2 weeks ago, there was an important event in what is so-called the entrepreneurial agenda for innovation in Brazil. And they said, look, we do not, we need to rethink the IP policy in line with these new development orientations. We do not want to be simply substituted imports. We want to participate in the global innovation chains. And this is I think that the spirit of all these changes is to build a new role for Brazil and for South America in this so-called globalized knowledge economy. And this is what we're trying to do, and we understand that for this to be possible, to be feasible, it's absolutely necessary that we join forces together, these countries in the region, so that the region has a more clear and relevant presence in the global context. So we have been working together, to build sort of a strong office, which is possibly going to be a virtual office. We have much inspired in the European Patent Office model. But then we realized that the European Patent Office was created in a period when there was no IT facilities as we have today. So they had to put these thousands of examiners together there in Munich, and because they could not work from their countries. But now the reality has changed completely. So we can build this possibly the same result or even a better result, keeping people in their own countries, just linking together these examiners through a well-designed information system. And in doing this, we can avoid the necessity of that each country makes huge investments in their national offices. There's the phenomenon that Latin America has been growing very fast in the last few years, has a strong correlation with the increase in the number of patent and trademark applications in the region. In Brazil, for instance, we have been running to increase the OFC examining capacity, but reality goes faster. So we are always in delay. And we hope that together with the other countries, we can face this challenge in a much easier way. So that's the only thing I would like to comment, and then we can answer to the questions the audience may have.
The floor is yours. Let me start from the back there. You have you have it there. Identify yourself, please. And
Parga, the Office of Convenes of the Organization of American States. Thank you for the event and the presentations. Congratulations to the 9 offices and their leaders for advancing this project. I think it's very interesting to see the process of interconnection becoming a reality. So congratulations to Jorge and Jose Luis and the leaders of the other offices that are here in Washington and at this event. My question for you is, as you advance in this process of interconnection of offices, and while respecting the national interest and the sovereignty of each of the participants, how do you see the process of advancing the policy dialogue on the pro-innovation environment, cooperation on technology transfer, and all the other elements that could be developed besides the interconnection of the offices? Do you see that Prosur could be a platform for that, to cooperate among the 9 countries? And how do you see this process evolving?
now, should we take a few questions and come back? And maybe let me get a couple more right here. Gentleman here.
Yes, I'm Dr. Sam Hancock of Emerald Planet TV. And looking at the work that you're doing, there's many different countries, and in South America you have many different sized countries. But one of the big challenges today, of course, is the theft of intellectual property and intellectual property sabotage in some ways, and also procuring by extraterritorial means. So how do you protect the intellectual property, since you're going across, different platforms, different nations, so that everybody feels like they truly are protected and that they can retain the value of their intellectual property and also their trademarks that they're spending much money in, and of course now is becoming really the true capital of many companies is the intellectual property. Thank you.
And Leticia, I think, has a question.
Hi, I'm Leticia Lewis with BlackBerry. I have a question. So to any one of you who wants to answer it, I think that a common theme in all the presentations was the sharing of information amongst all the offices. I think that's with the scope of consistency, so everybody can work together and exchange information. But based on that, are there plans that users can have just one single application? And more specifically, I have a question for you on Brazil. So what's the status on the Madrid Protocol and Brazil adhering to that?
And before you answer the Madrid Protocol, you're going to have to explain to a lot of people what she's talking about. Yeah. No, let's start, and who would like to go first?
Well, I think the first question was about Prosur and whether or not it could be a good base to start working in some extra borders research projects. And yes, obviously, IP is so connected to research and development. And yes, it is currently the research industry is no longer a national industry. So nowadays we're talking about collaborative international research chains or cycles. And so you can see how one enterprise is perhaps working with another university and a research center in various jurisdictions. So at the end, if you facilitate the way you can apply and protect your IP portfolio, inventions, trademarks throughout different and many countries, there's an incentive for those who are working together in research to also do it in a transnational way. So, yeah, I would say it's a good basis.
Continuing, would you like to?
I can address his question. If I understood your question correctly, you actually asked if in this scenario, if IP is safe in Latin America or not. Yes, I think that making the world a safer place for IP is the challenge we are all facing together. It's a major global task. And I think it's such a huge task that it cannot be addressed directly or by one organization. The WIPO itself alone would never solve it. So I think we are doing really a very important job. And I think that all the countries I have visited, we have a cooperation agreements today with Canada and other 40 countries. And I think that Canada probably also has with several countries, and United States possibly with all the countries, I don't know. We are trying to really build these links in order to make it easier for users to achieve, to understand the system and use it the best way possible. In Latin America in particular, we have an extra challenge, I'd say, as in most developing countries, that users are not used to the system. So there are many people who should be users and are not. People are not totally aware of the relevance of protecting their IP. And when they are, many times they are protecting only in Brazil, and they don't pay attention to the fact that the Brazilian economy is open, and that if they don't protect their IP outside Brazilian borders, they possibly won't be able to do anything with their IP. So I think that the world is, internet is a challenge. You work for a TV, a broadcasting company. So it's internet must be your hell. You publish something on TV today, and tomorrow it's on the internet, in YouTube, and I don't know. But I think that everywhere people are looking for solutions for this problem in order to maintain the incentive for people to generate good programs as the Animal Planet does. And so I think it's a challenge. But I'd say that I've been in China, I've been in India. I think that everywhere the authorities are very much concerned with this and very much aware of the need of cooperating for building a safer place for IP.
Mm-hmm. How about Leticia's question on...
Leticia's
question on...
Not only Madrid, but the first one, which was one single application, right?
Yeah.
Yes.
Yeah.
You mentioned that the same notification, but then the next question would be, would that evolve to one single application at one point? And general question, more specific, what's the status of it?
And please mention the Madrid, because they all know what the Madrid Treaty is, but I don't, so...
I'll leave Madrid in for just a moment. Big step between common classification documentation to just even unify examination, let alone get to a. We'll see exactly how the experiment well, true, and we'll see how the experiment works in Europe. As we head into that, that's going to be a great example of how multiple countries can get together on a single courts and single applications, which is also the big problem of it. Sometimes looking at it from a single application perspective is almost the easy part. It's the back end of the process of what do you do to enforce that and who's going to respect that document, that right across borders is the really, really tricky part.
Oh, but
I don't think they can be separated completely.
but if I may add, Mark, the thing is, there's been initiative about that. I mean, if you take a look at the PCT is not only a one filing application to many countries, but to cooperate in one preliminary examination. However, the problem is that you have to harmonize more than 180 countries in their substantial law. So try to find one single application to meet the substantial law is different to find one application that meets the formal requirements, which are different. Okay, so what the state of the art right now is that we all agree that perhaps one single person or one single entity could conduct one single search, and we recognize their competence to do so, and then we decide whether or not, based on that report, we grant patent or no, based on our substantial law,
And trademark too.
Yeah, yeah.
which is the same with trademark.
Yeah, but just to add something to this, I think that I'd say that years before, people say that a single application form was already not welcome because it would hurt your sovereignty. I think that this view is surpassed. So a single application form, I don't see any difficulty that in the near future will be, but a single examination process is already something different, because the countries still have the right to legislate it differently. So the extension of rights and things like this are not totally harmonized and possibly will not be shortly. So we're possibly going to have one single form, a collaborative examination process, and individual national decisions or regional decisions. It's possibly going to be easier to harmonize regionally than globally. I'd say that this is the process. Regarding specifically the Brazil and Madrid Protocol, the news are good. But it's we have to wait and see if everything goes the way we think it's gonna work. Because I remember 4 years ago I said the same thing here.
That's
we
why-
have again approved in all the intra-government entities, because changed the government, and then everything which was done had to be redone. Because when the new government begins, the palace sends back to the ministries to reaffirm their interest that that project of law goes on. So 4 years ago, we had gone through all the technical entities, intra-government, and everything was ready to be sent to Congress, and it was never sent. Now, again, we made all this process again in the new government, and it's ready to be sent. And we are doing our best efforts to make this happen. And we made one thing different this time, because we learned that some lawyers did not want that thing to go on, and that they were very strong and able to somehow slow the process and even stop it. So we put the companies closer to the lawyers they hire, in order to be sure that the lawyers will not act against the company's interests. And so maybe this time it works.
George, one of the things that happened in 4 years that I knew what the Madrid Protocol was, but I forgot. So please explain what the
Sorry.
Madrid Protocol is.
The Madrid Protocol is a global cooperation agreement which has to do with making trademark applications, make it easy that you protect your trademark in many countries with a single application.
Okay, let's go here to the question.
I am Snakes Panagidis of Innova International. I have two questions, one for the panel, one for Dr. Avila. One of our companies is developing a security program that is developed, part of it in Buenos Aires, the other part in San Francisco, and one part in Washington. In such a case, where is the ownership of this, and what should we know? The panel probably can address this, and it's not a unique problem, but it's a common problem. I must say that's a company my son is in charge. Incidentally, I urged him to register the product, and he said, no, the best way is to be ahead of the competition. You don't need a trademark. You have to be ahead of the competition to compete. My second question is for Dr. Avila. Not too long ago, the state of Pernambuco was a least developed country, state. It was not a very developed state. Today, I understand, is an important IT state. And if you would like to comment, what explained that success? Thank you.
Okay. Any more questions that you have? Yes, there is one very back there.
Okay, I wrote it down because it's a little bit long, but anyway. I'm Andres Izquierdo. I work in research with two NGOs and with partly with American University. And we have been focusing in this kind of these modifications of the IP norms. Hello. Yes.
Going.
Now my
Let's change it.
maybe. Thank you. My question is regarding Prosur. From your presentation, I know that you are working closely with WIPO to develop the project. I can believe that. I know that you are aware that the new IP regimes have been highly criticized by civil society. As a matter of fact, the last two copyright laws in Colombia have been struck down because of civil society concerns, and also because of a ruling of the Constitutional Court that came down last week, well, 2 weeks ago. Well, this is not only limited to copyright, but it clearly extends to industrial property with patents and trademarks regarding the TRIPS agreement and all TRIPS plus regulations. From your presentation, this project seems as a TRIPS plus implementation process. If your Prosur project for trademarks and patents is accomplished, there would be not a huge difference with the Madrid trademark agreement or the protocol and the new fast-track patent approval process. Could you help me clarify the impression that this is not a straightforward TRIPS plus policy? Also, why is there no participation in civil society in this project? And shouldn't this project be addressed as a Latin America treaty instead of a project of the Inter-American Development Bank? Thank you.
¿Más preguntas o esas tres? ¿Those three?
No, let's do. You have a question there? No. So
I think we'll Jorge start with the first two.
Which, the first one was who's the inventor, who's the inventive entity?
Well, in cross-border R&D activities, the ownership is something which is decided by those who invest in the project. So it's for instance, if an university cooperates with a company, Brazilian university cooperates with a Argentinian company, the ownership of the patents which are generated might be decided by both parts. This varies from country to country. In the United States, I think the law requires that the university maintains the ownership. In Brazil, it's up to the parts. So national laws can differ, but in general, the effective ownership, because you can be the owner, but you can grant a exclusive license to a company here in the United States. So the effective power to deal with the patent is decided in a negotiable basis between the parts. And those who fund the research have the power to decide. And one other important thing is that in many collaborative R&D projects, parts of the research are done in different countries. And they result in different patents. So part of the patents will possibly belong to a university in one country, part will belong to a company in another country or to an university in another country. So this is really a very variable geography. Maybe you should pay attention to the fact that patents protect very small achievements. And a relevant innovation is most probably a composition of several patents. And the ownership can be really shared by many people. In Brazil, for instance, if you do research on genetic resources which involve traditional knowledge, part of the ownership will belong to Indian communities and things like this. So it really depends on the legislation of the country and on the agreement between the parts. The other one was?
Pernambuco.
Well, the state of Pernambuco and IT is a very interesting case. I know it superficially, so I'll give you a superficial answer to your question, but I can send you more detailed information later if you want. This was really something which happened somehow spontaneously, that many companies were created in the metropolitan area of Recife, which is the capital city of Pernambuco. And then there was a clever decision taken by some university-related entities, which was to give these companies, to promote links between the companies, and to give them some kind of technical support, especially to protect their IP, and to help them make good business models and find investors. And this resulted very adequate, and it allowed these companies to grow. And today, Recife is really one of the important IT production centers in Brazil. So, but I can send you more historical information because I don't know much more than what I have said here.
Just to complement this, we were just in La Jolla in California, and one of the, actually the president of Interpharma, the Brazilian trade association for pharmaceutical industry, described this process talking about, you know, in order to innovate, you always need a bunch of malucos. Which is people that are kind of crazy, sort of scientists, scholars, etc. Absolutely dedicated, single-minded people. And it's always, you go to innovation centers, you always find 3 or 4 of those that will get together with business-oriented people, and they form, and this happened in Pernambuco. I happen to know a bit about this because it were a bunch of professors from the Federal University of Pernambuco that taking the opportunity it was given by those initiatives, decided to create a center for the training of computer engineering engineers in Recife. And nowadays, they have a major problem in Recife because as soon as those kids have their diplomas and have their training, they go to Cambridge, Massachusetts, you will find a bunch of them because they are offered much better salaries there. And when we brought our first group of congressmen, 18 members of the Brazilian Congress, to MIT, Tony Knapp from MIT, Brazil, is a very funny guy, started by thanking very much the Brazilian congressman for investing Brazilian public money to train such great computer engineers that are then have difficulties innovating in Brazil because of lack of venture capital and all the things that we discussed here over the years. And then they end up all in Cambridge, Massachusetts, and some of them get very rich. So, but the story is, it has to do with the dedication of a group of professors that started this about 35 years ago.
There's a peculiar thing about that.
Yes, in the sense that from what I know is that in Recife, at the Federal University of Pernambuco, they created a space to have what today I think it's called the Porto Digital, right? And the digital port. And it is a very successful operation.
Yes, one peculiar thing about that is that they developed such a different way of doing businesses, collaboration between university and so on, and this became very famous. And so they applied for a geographical indication for IT services. And we granted them, because in the end, they showed that they had some peculiarities, and it could be a collective trademark. But as they wanted a geographical indication, it was possible to grant it. We granted it.
There was the complicated question.
There's you begin?
I think was addressed only to Colombia.
Yeah.
Oh, yeah.
Well, you mentioned lots of things as to what is going on in Colombia right now, but in order, for the sake of clarification, the first one, which is related to the a new copyright law regarding internet and some kind of internet rights. let me clarify that the Constitutional Court didn't believe that the law was not constitutional per se, but that the project was submitted to a commission within the Senate that didn't have the competence to start the legislation process. So it had to be submitted to a different commission, okay? That's the first, I think that will answer your first question. The second one, which is related to Prosur. First of all, our law invested in the national office the power to rely upon other offices' patentability reports. It is not said in TRIPS, in fact. It is said in our law. However, that is not the problem, because we haven't changed a bit our law. At the end, if one of our examiners sees what other examiner, say from Uruguay, has performed in a particular case, he's somehow taking a shortcut to see what was the state of the art, and based on that, he will notice and notify the applicant whether or not his application will be granted or not. And the applicant hasn't lost its right to file reconsideration actions, responses to the office action, and at the end of the day, there's no limitation to the whole process of patentability. We haven't, if you want to say so, we haven't discussed this with the civil, I don't know, associations or whatever you want to call it, because we believe this is a demand from them, you know, from the users. If you take a look at Colombia's situation 3 years ago as to the backlog, and all the users were complaining that a patent process took more than 8 years, and now it's taking 4 years. I think we are going to the right path to respond to their needs. And none of the applicants, if you may say so, are against this kind of process, because the faster they get the rights or the decision, the faster they get the certainty as to whether or not they have to enforce it. And even for the non-applicants and the third parties, this certainty is better off for them as well. So at the end, this is not a matter of discussion within civil society or not. It's a matter of how you administrate the office. And I don't know if you have you mentioned something about the PPH, which I think it was answered by me with the first of the answers, which is I have the powers invested, well, when I say the office, to recognize different reports from different offices. In fact, we are part of the PCT, and the PCT is not only one single application to different countries, but the recognition of authority in different offices that they can perform preliminary examinations and reports, and we can rely on that to base our decisions. So it's not a trip plus.
No, just a short comment on that. The TRIPS is a minimum requirement agreement which establishes minimum basis of harmonization in order to promote collaboration. Of course, if you want deeper collaboration, you need more harmonization. This is what's going on in South America. As we want to cooperate more and more, we need to have our systems closer and closer. And this is just a natural movement which has to be done, to be seen, is that TRIPS is not more than this, not more and not less. It's just an agreement on minimum harmonization criteria. And the governments, elected governments of the region, are totally sovereign to decide on the laws that should apply to their jurisdictions and to cooperate deeper and deeper if they want so. And so this is what's going on. Prosur is a totally voluntary-based process. No country is being obliged to anything by any international treaty or by any international pressure or arrangement. WIPO has been very useful, providing us some support, sometimes technical support, though we do not use WIPO case. We started using it, but then we abandoned it because we decided to have a stronger tool. And it was it's just an absolutely sovereign decision of the United States to be engaged in this, and we don't really see anything in this which might be seen as a TRIPS plus international obligation. No. It's a decision of strong cooperation, sovereignly taken by the 9 offices and the 90 countries.
Let me conclude taking the privilege here of the chair asking you a question. Obviously, we all read the piece this week about a decision in India regarding generic medicine, which is obviously in everybody's mind. Brazil at one point regarding HIV medicine or AIDS issued some compulsory, just one, but there was there was an important change at the beginning of the rounds at the WTO. Actually, it was that agreement that apparently helped to launch the round. And in our exercises, these 3 years with the congressman, there was, for instance, the director of the genome project at Oxford University that happens to be a Brazilian. Nobody knows because he has a Chinese name, but who, talking to people from the pharmaceutical industry, raised the issue, aren't you patenting some things too early in the process? By doing that, you inhibit innovation, because scientists, when they see that something is being protected, they go somewhere else. There is this case of China that has obviously a clear political and social element to it, right? And as experts, is this the biosciences area? Is this the most complex? Is this the most challenging area for you that have the responsibility to examine those things? And I'd like to bring Konstantinos in, because he has been quiet in this one, because we know that Canada is a very innovative country, including in this area.
Okay, thank you. Let me start by avoiding your question altogether. And no,
I'm
seriously,
a journalist, so I try to get people into trouble all the time.
Looking at the various technology areas, I think, is the next level of trying to understand businesses and innovation. We often speak at the very high level in terms of understanding R&D and intellectual property, patenting, but when you bundle all the technologies together, it really does mask or obfuscate what's happening. On the life sciences, biotechnology, chemistry, I mean, that's one type of intellectual property. There are the blockbusters, there's the litigation, there's the battlefield. What about the 98% of the rest of the companies who are innovating using an IP? How do you create the right system for them? And that's what we're trying to understand in Canada. Yes, of course, looking at life sciences and pharmaceuticals is very critical for health and science, but also understanding all of the other technology areas is equally important for us to understand at the micro level what is happening, what are the barriers, what are the challenges that companies are facing. And I think that's where we need to start looking to the future, to understanding innovation and intellectual property. And then understanding, again, at the micro level, what are the challenges that the companies are facing. And that's where I see there's a lot of fertile ground for us to collaborate, because a question came from the floor in terms of who owns the right in which country, in which which innovator should own the right. My sense is that we're looking at the world from the IP office. We're looking at the world from the IP attorney. We're looking at the world from intellectual property and patenting. We really need to step back and say, the IP strategy does not begin and end with an application and a grant. what happens before? What's the IP strategy? What's the business strategy? Here's your right, but how are you going to work that? How are you going to roll it out in the market? How are you going to use it, collateralize it, monetize it, use it to then build a business and roll out products and bring that to consumers? That's the aftermarket, if you will, but that's part of the big innovation system. So I think I've avoided your question entirely in terms of pharmaceuticals, but I really want to demonstrate that you need to get down to a much more detailed level to understand what's happening to support it.
So I don't want to put more people on the spot, so with that, I would like to thank José Luis, Mark, Jorge, and Constantinos very much for your presentations, for being here, for sharing all this work you are doing together with us. If you have, as this work evolves and you have more results, please come back. We're always open here to discuss, to present the good public policy efforts for all of you. Thank you very much on behalf of the Latin American Program, the Canada Institute, the Brazil Institute, and the Program on America and the Global Economy. Come back.
Thank you.
Thank you. Great. So you.